the court to stay its hand, tried to pause New Falmouth from getting possession of the land, and sought an injunction against New Falmouth to stop New Falmouth taking possession from the 99 people. The court the basis on which the Minister of Housing at the time sought to get a stay and to get an injunction against New Falmouth was that the minister, after New Falmouth won in the court, the minister claimed that he declared the land to be improvement area under the Housing Act, and so he was at liberty to take over the land compulsorily. And a number of affidavits were put in. New Falmouth resisted the application, told the court of the history of the matter. And in fact, when the Minister of Housing's application went before the court, one judge heard the application, hearing only the minister's side, which is called the ex parte application, and granted the Minister of Housing an interim stay for 30 days rather, and set the application to be heard with both parties present at a later date. When the matter went at a later date with the two parties, that's the Minister of Housing and New Falmouth, before another judge, the judge heard the application and the judge granted an order restraining in 2012 New Falmouth from interfering with the 99 people against whom the application was initially brought by New Falmouth. Then now, later on, when the application, another application for stay of execution, and after hearing submissions from counsel for the parties, one of the judges adjourned the matter and requested either the minister or one of the people who filed an affidavit to appear. According to this history of the matter that the Honorable Mr. Justice Frank Williams gave in the Court of Appeal case, he said on the 4th of May, Justice McIntosh delivered his decision dismissing the application which was brought by the Minister of Housing. The judge says neither the minister nor Shukir appeared in court. However, the learned judge recognized the presence of officers of the Housing Agency of Jamaica, Mrs. Simone Morris Rattray and Mrs. Janice Buchanan McLean, and handed them a copy of the orders which he'd made. There was no appeal from the learned judge's decision. The reasons for the learned judge's decision were contained in the formal order filed on the 18th of May 2012. And this is what the judge wrote in the formal order. It is clear from the application to stay execution, so this is when now the Minister of Housing applied to halt New Falmouth taking possession, and the court denied the minister's application. These are the reasons the judge has put out in the order. Let me take a break and come back.
The Jamaica Civil Service Association.
Good of our nation.
So this is what the Court of Appeal recites as the reasons Justice McIntosh dismissed the Minister of Housing's application for a stay of a judgment previously given in favor of New Falmouth, and the court also dismissed the Minister of Housing's application for an injunction to stop New Falmouth from removing the residents from 2010. This is what the judge said. It is clear from the application to stay that it is intended to be an indefinite one, as there is no indication of a date or period for allowing the claimants to have the fruits of the judgment or award handed down in their favor. In other words, whatever it is the Minister of Housing said it was intending to do, there was no period by which it was indicated it's going to be done, and that indefinite nature, it allowed for some vacillation, some uncertainty about by when New Falmouth could have the benefit of the judgment that New Falmouth had. 2, the presence of legal officers from the housing agency may be intended to suggest to the court that the government is taking actual and immediate steps to assist the parties in a mutually beneficial settlement. 3, actually this is stated as 5, so it's 3, 4, 5. I suppose 1 and 2 were not that material, so the Court of Appeal judge didn't cite them. Given the history of this case, the length of the trial, and the efforts made by the court to assist the defendants there are the people who possess the land. Let me read it again. This is what the judge said. Given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act, this court empathizes with the gullible defendants. 6, the application, this is the application by the Minister of Housing to stay the order of the court, which was granted in favor of New Falmouth, and the application for injunction. The court said the application is iniquitous. That means it is grossly unfair, it is morally wrong, it is wicked, it is unjust. This is what the court said. This is not the first judge, this is not the second judge, and this is not the third judge reciting the facts. It's judge on top of judge on top of judge. The judge continues. It may be that the law is not a shackle to the lawmakers. That does not apply to the court, which must dispense justice according to the law. 7, it is the court's view that the application is devoid of sincerity. It is an attempt to pervert the course of justice and an abuse of the process of the court. This is what the court is saying to the Minister of Housing based on its application to stall a judgment that was given to New Falmouth years before. The application is refused with costs, so they're supposed to pay the cost for New Falmouth. And as I told you, when you read the affidavit of Mr. Chisholm, Mr. Chisholm is telling them from 2002, he went to every agency begging them, please help, please find somewhere to put these people. I need my land, I need this, I need that. Not one soul batted an eyelid. The court accepted that as fact, because anybody can say anything in affidavit, but for the court to accept it, it went through a process of examination, cross-examination, passed the test of admissibility, passed the test of hearsay, and the court accepted it. Right? So the court granted the Minister of Housing leave to appeal. Then on the 1st of May 2012, the minister lodged a caveat against a certificate of title for the land and gazetted notice of the subject land being declared to be an improvement area pursuant to Section 6 of the Housing Act, published in the Jamaica Gazette. So I heard Mr. Cousins yesterday talking about the gazetting. And when you look on the face of the title, it is there, gazetted. But there's a backstory behind it, and this decision outlines for you what the backstory is. In fact, I don't even know. Something else must have happened, because I don't know how this caveat remains on the title with this particular decision of the court. It must have lapsed, or it should have been removed by some means, unless there is an intervening court action that has caused it to stay. So if you look on the title and you see this caveat, which is actually lodged the 1st of May, you may think that the Minister of Housing is properly entitled to some sort of equitable interest in the property. But based on this decision, which they appealed and lost, there could be no such entitlement to the maintaining of a caveat on New Falmouth's property, unless there's something I'm missing. So the court then goes now to the, after they lodged the caveat, they filed another claim in the court, a separate action now in 2012, a fixed date claim, where they sought several declarations, and that's part of what I took you to, including one that they were entitled to compulsory take over the land. They filed a notice of application for injunction, fixed date claim form supported by affidavit of Miss Simone Morris Ratchery, and it goes on. New Falmouth's lawyers, in response to the application filed by the minister, they filed an application for court orders, seeking as a matter of urgency to strike out the minister's application on the ground that the application was an abuse of the process of the court, and it was really in substance the same relief that were sought under the other claim. Right? So all of the things I read to you before sound familiar, because what they did in 2012 was to file a new claim where they were seeking sort of the same remedy. And so on the 21st of May, Justice Harris, then acting after hearing submissions of counsel, ordered by consent that New Falmouth and its agents be restrained from dealing with the land and from interfering with the occupants without the consent of the minister until the 7th of June 2012. So the matter was adjourned to that date to be heard. And the matter then went before Justice Campbell on the 21st of May 2013, continued over several months, at the end of which Justice Campbell ruled that the application before the court, which was brought by the Minister of Housing, was an abuse of the process. And so it dismissed the Minister of Housing applications and made the orders which I read to you earlier on in my views. So this is probably now the third, maybe fourth decision in favor of New Falmouth before 5 different judges. Couple of them granted interim injunction. Couple of them after inter partes hearing granted injunction by consent. But every step of the way, New Falmouth was policing the matter, begging for help. No government agency helped. Then the minister came and sought to do executive action, then applied to the court. The court said, no, you cannot usurp the function of the court. You cannot do something that the court has already ordered is to be done, and you haven't appealed that decision. We're going to stop it. And they appealed to the Court of Appeal. When they appealed to the Court of Appeal, these are the grounds that they appealed. They wanted the court to say that the judge, this is Justice Campbell now, misdirected himself in fact and law when he found that the alleged purpose of the minister is not for general interest of the community, but merely for private individuals voluntarily associated together for their own benefit. They say the learned judge, Justice Campbell, in finding that there's no public purpose to the compulsory acquisition, failed to appreciate that definition of public purpose would take into account the benefits that would redound to the community as a whole, and in so doing, they're saying the learned judge misconstrued the provision and the intent of Section 25 of the Housing Act. They also sought from the court agreement to say that the learned judge misconstrued the meaning of Section 25 of the Act and exceeded its jurisdiction by exercising a discretion reserved for the minister. They say they wanted the Court of Appeal to hold that Justice Campbell failed to appreciate and or misdirected himself in law when he found that the principles of res judicata and abuse of process were relevant to the proceedings before him. In other words, the matter tried already for the same thing, and you can't come back and repeat them here in the subsequent thing. They wanted the Court of Appeal to say that the judge, Justice Campbell, erred in fact and misdirected himself in law when he found that the relief sought in both claims was the acquisition of the subject land. They wanted the Court of Appeal to also say that the judge erred in law when he found that the identification of public law issues is insufficient answer to New Falmouth's argument that the issues have been ventilated before the court. And so they lay out about 10 different grounds of appeal that they were challenging Justice Campbell's decision on. And a panel of 3 judges, Justice Phillips, Justice of Appeal Brooks, so these are all appeal judges, and Frank Williams, heard the Minister of Housing's appeal. This was heard October 2025 and April 2015 and April 2016. And on all of the points that they argued, those points of appeal that I mentioned to you, some of them that I read to you, the Court of Appeal concluded, in light of their analysis, I am unable to say that the learned judge, this is Justice Campbell, fell into error in his overall analysis and treatment of the issues in this case. The later claim, which is the one that the minister filed by a fixed date claim form, having been in substance the same as the earlier claim and appearing to have the effect of attempting to circumvent the orders of Justice McIntosh, they clearly amounted to an abuse of the process of the court. That fact, coupled with the minister's failure to demonstrate compliance with the requirements of Section 6 of the Act, helped to seal the fate of his applications. In these circumstances, it could not fairly be said that the learned judge was palpably wrong. I am therefore of the view that the appeal ought to be dismissed with cost to the respondent, that is New Falmouth, to be agreed or taxed. 3 judges, unanimous decision, 20. And I'm up on a break.
You're tuned to Radio Jamaica, effective.
We're back with you. So, all of that whole heap of things, and I'm sure there are probably more matters. I've been trying to reach Counsel Juliet Melrose without success, because I see her as a common, one of the counsel appearing in multiple matters for New Falmouth. If anybody knows Counsel Mrs. Melrose and if you can get a message to her, please tell her I'm desperately trying to reach her, because it seems to me that every single thing that was legally desirable, possible, procedurally correct in seeking to have the court declare who is the owner of the land, having had the declaration, having the court order possession of the land, and then resisting what I consider, forget my consideration, I accept the words of 2 judges of the Supreme Court, the iniquitous application by the Minister of Housing. And I tell you, this is part of the challenge that goes on for me, You have these guys who talk about judicial independence. The court assessed based on evidence before it. People subject to cross-examination. Submissions in law went before the court. After years of pleadings being filed the court, after months of trial before the court, and a tribunal of fact assessed credibility, look at the cogency of the matter in law, and came to a decision. And a member of the executive turned around and declared the area over which the court made an order to be an area that it can compulsorily acquire, with the intention of thwarting the decision of the court, put a caveat on the title, gazette its action, then turn around and sue the man who got the decision and try to get an injunction against the man. The man challenges it. And when the man challenges it, another panel heard all of the arguments and stopped the minister and said, no, what you're coming with, we've already heard and decided it, and your application is ungodly, unworthy, it is wicked. And what is happening is that you, the politicians, have made the people believe that it is okay for them to stay here and to consistently and constantly deprive the registered title holder of his interest in the land. That is not right. That is not constitutional. That is not legal. No. And they challenge it to the Court of Appeal. 3 judges at the Court of Appeal unanimously said, the judge, I cannot find any way to say that the judge is wrong. So you, minister, you lose. Not only have you lost, you need to pay New Falmouth's lawyers their cost of the appeal here and below. Yeah? And I hear people now telling the government that they must take action akin to what the Minister of Housing did in 2012, which the court has already frowned upon and labeled it as iniquitous. So the question is, do you think that any litigant who has so prosecuted this matter over nearly 20 years in the court, brought his action, resisted adverse applications, consented to interim injunction until things are settled, you think that those people would not seek to ensure that they do enforcement according to law? So when I hear the story, the first thing I'm saying, but police can't just go so. Was there a bailiff involved? There must be a bailiff involved. So yesterday, I'm making all of the inquiries the day before. Was there a bailiff involved? Before the bailiff, is there a writ of possession? Because as I said to you, even though these orders were formed in the court, New Falmouth has to go a step further. When they serve the order on the people, some people might move, some people might not move. And for those who have not moved, they have to go back to the court and make an application to ask the court to please issue a writ of possession, because they still have not been able to benefit from the fruit of the order. So I got a copy of the order yesterday. And apparently there was a hearing on the 19th of May 2026 based on an application which was filed on the 30th of March 2026. So on the 19th of May, after the judge heard the attorney for New Falmouth, the judge granted the orders which were sought in the notice of application. There are 1, 2, 3, 4, 5 pages of defendants. So it's between New Falmouth and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 99 or more different people as defendants. And this went before another judge. And for the judge to have granted the order for the reissuing of a writ of possession, the attorney needed to have satisfied the judge that all other orders in relation to this matter, they'd been served. And when the judge is satisfied, then the judge can go to the reissue. I don't know when the first one was issued. That I'd like to know, because part of what I don't understand is what happened in sort of that interregnum between, say, the Court of Appeal decision and this application for the reissuing of the writ. But as I've explained, it is when the attorney has a writ of possession that the attorney goes to then writing to the bailiff to prepare for the bailiff a sealed copy of the order so the bailiff can feel the seal of the court on it. Engage the bailiff, settle whatever fees. The bailiff gets in touch with the police. The bailiff doesn't deal with service of papers. The bailiff comes in because papers were already served. The court was satisfied that the papers were served, hence the writ of possession has been granted, and the bailiff goes in. If it's a levy, it's a warrant for levy, then the bailiff needs permission. But if it is for possession, no permission is needed. The bailiff goes, the bailiff will take out whatever is in the house, take them off the owner's property, and the bailiff's role based on the order of the court is to remove whatever is there by whatever means necessary, because the people have already been notified, must have been notified that at some point in time you've lost the right to be here. Not right. You've lost the chance to be here. So that's how I know that it works from start to finish. I've been trying to reach the High Command, spoke with a member of the High Command yesterday, spoke with the Minister of National Security to get some more information, because yesterday John called to say he understands that police detained young men, took them out before the operation and then took them back. All of that information, I need to understand what happened. Is it that operation, the pre-dawn operation, is it one and the same as the demolition action? And if so, how come? Because the police who go with the bailiff are not police who would be arresting young people or old people. They sort of go there just to keep the peace. That's why you engage them. Sometimes you send people to go feel the lay of the land, and when you realize that it is potentially dangerous, even the bailiff will say to you, we are going to need to have police presence there to make sure everything is okay. But those police invariably are not police who are detaining young men. So something seems amiss to me based on how I know that these things are supposed to work, which is why I'm asking for the High Command to say, what is this pre-dawn operation that took place? Is it connected with the bailiff and the police going there? And if it is separate, how can it be so coincidental? Yeah? So before I come to anything else, there are a lot of things that have to be satisfied in my head. And the other question we have to ask is, really, what does a registered proprietor of land who has done all of these things, what else does he do? What else? I mean, when I look and I see that a young lady, they say, was put out in the bus stop, dreadfully awful scenes. But also the mere fact that a new generation is coming is indication that New Falmouth was never going to get the fruit of its judgment. So, just what happens?
Rise together, strong.
For the good of our nation.
I continue to see who we can get from the High Command. Nobody has responded yet. And also trying to reach Counsel Juliet Mayer Rose, who is one of the attorneys who appeared before the court in the 2007 and subsequent applications, and also in the application for the reissuing of the writ of possession. I need to check on the something related to that date. Let me come to your calls though. 876 9262178, 9268631, 9267615, 888 991 2080. Let's see. So this order was made in May. It looks like it was filed in August. It went before the judge on the 19th of May. This is the hotline. Morning.
Hi, good morning, Mr. Hughes.
John.
You know, I see something here from the principals and vice principals of schools. It's saying that the charge of teacher is becoming a crisis. You know, we see this thing happening every year, and we are not putting in anything in place to retain our teachers. I remember in June election campaign, there was a proposal put forward by the PNP on how to retain teachers in our classroom. And you know, sometimes we look at certain policy position that has put forward, and it is a good thing. But because we are not a part of that party, we do not take them on board and run with them. Because I'm going to tell you something, I'm the shield. There are schools where sometimes our children for the day have had one or two teachers. And not because the teachers don't want to teach them, everybody there. But the thing is that they don't have enough teachers.
What is it that is being done now? And what is it that has been proposed that is not being done?
All right, the PNP, I propose, I'm going to treat like the PNP has proposed. They had proposed some removing of certain tax and learning equipment what teachers are going to use. And teaching equipment teachers are going to use.
Like what? Like laptop?
Like computers and things like that. You know what teachers use ministry.
Then hasn't the government given laptop to teachers or provided that particular benefit that you're talking about?
Providing two laptops to teachers.
Oh, Jesus.
When there are thousands of teachers who are using laptops, and we have to buy them. That's what we're talking about ministry. There was also a proposal for the NAT rate dramatically for teachers.
There's hardly any NHT any interest being charged now to public servants.
Mr. Shields,
Hardly.
Mr. Shields,
Yes.
you can't do these things.
To do what?
Whenever you see some proposal for the PMP, you shall throw cold water upon them.
Yeah, but you
And tell them what is happening and what is not happening.
John.
These proposals, Mr. Shields, if they
No.
had taken them on board, I'm sure today we would not be having this conversation.
John?
That we are in a crisis level now.
John, if your proposals are so great, what you need to do is to make sure when you come here, not only are you speaking truth, but you're saying something that is not actually happening. And I'm just checking with the NHT now the rate of interest that teachers enjoy with the trust to remind myself whether it depends on the salary or whether there's special rate. Yeah? But as far as I know, one of the things that every government does, they sweeten the pot for public sector workers with the NHT yearly.
But Mr. Shields, it doesn't matter what you come with.
Oh,
What the principals are saying
that's a different
is
point.
a shortage of teachers.
That's a different
at
point.
Crisis level.
Anyway.
And something must be done about it.
All right, thank you for the call. Thank you. 876-926-217. Make that 8631. Morning.
Good morning, Mrs. Shields.
Hi, who is this?
This is Lynn.
Yes, Lynn.
You know, no joke this morning at all, Miss Todd.
Yes.
Let me tell you something, man. At the worst thing we do a fight over land. We know to fight over land, you know.
Yes, true.
Yes, and you see the owner, the land there. My God, they left it, you know.
Yeah, I believe he has.
Mister,
No, I believe he has died. I believe he has died, but what?
Then I want it.
It's a company. It was held by a company. It was never held in the name of an individual. It's a company.
Let me tell you something, man. At 2 times, I watch the news now and I cry, you know. When the woman cut the little pit in the neck, and when me see the bulldozer lift down the house there. You know how much for a bag of cement? Eh? And steel? What you expect the children them to do? When them see their mother and father house a bulldozer? Eh? And we are talking about crime in this country.
No, but Miss Lynn, you can't. That's where you start.
Eh?
That is not there. You can't start there, so.
But if me see me live in a house tonight, and tomorrow morning me under plastic, where them a go with plastic when people build them little house?
No.
And have them bathrooms
But let me ask you something. The house that you live in now is your land? You live on your land? Eh, Miss Lynn?
It's in his house, the name upon the paper.
Yes. So what if tomorrow morning some whole heap of people come and put up structure in front of your house?
Not a truck that can put up, because my land no give me no space to come put up. Thank God you no give me no space so nobody can capture nothing.
Oh, so you don't...
And you know what happened?
Yes.
From the first house put up, and the second house put up, and the third house, nobody stopped them.
No, that's not true, Miss Lynn. That's not true. This is why when I look at the court paper, and I went through it this morning, the man brought a claim 20 years ago. And before that, he told the court from early 2000, him beg HAJ, him beg the Prime Minister, him beg everybody, please get somewhere and get the people off the land. At the time, he brought a claim against 99 people. And every step of the way, he's begging, beseeching the government agencies to help long before these structures were what they are now. And nothing was done. What does somebody in that position do?
You don't have to handle people them like that.
No, but
you don't have to be taking away young men and go put them in a jail. And
no, but that's a different.
We still under slavery, man.
No, but that's a different point. So this is what I'm saying. I don't understand that part, and this is why I'm asking the High Command to explain what led to this pre-dawn operation, because that is not a part of enforcement to get back possession.
Like I tell you something. Everywhere you drive in Jamaica, you see government land. Why the government won't give people place to live? And let them pay for it. Everywhere you drive in Jamaica, it is over high land and it's for government. Why then don't give Jamaica people place to live and lick down them house them a bit? It's not right. Murder, police, right. The world is looking at us. You can't bulldoze down house with old people. The old people to get money now to go buy a bag of cement and steel, look up. The government must look out for them people, man, and below and put them on their ball, murder, police. We want help in the country. Look out for the people that we vote for. No, murder.
Thank you for the call. Thank you for the thoughts, Miss Lynn. So I've asked Mr. Burbick, what's the rate of interest now for teachers? He says based off income, it's between 0 to 5% based on their applicable interest band. Since the 1st of July, there are interest rates discounts for every year, for years of service. So if you serve for 5 to 10 years, you get a 1% reduction on whatever the rate is. Over 10 years, you get 2% reduction. This applies to police, nurses, soldiers, firefighters, and they're finalizing discussions in relation to correctional officers. We have the right to our own opinions, not our own facts. And one of the things I'm going to always try to do is to correct inaccurate information. So long as the accurate information is known to me, I will let you come to your faulty conclusion because it doesn't seem faulty to you, but I will try to let you use the best information that's available. 2178. Hello?
Justice Toy!
Will you come to me at minutes to 11 for?
No, you have no call back in your church, sister. You have to put me on hold. You have to put me on hold. Yeah, me say to you. Morning.
Morning.
Morning, Jamaica. Morning, foreign. Hey, morning to each and everybody.
Mm-hmm.
Church, sister, when me leave, I rent me the PA. And let me tell you something. Me have one farmer, one female was packed on up there. They're not talking, sister, because they get notice. But politicians tell them say they are going to get the land, give them. And that's the story, you know, because they can't talk, you know. And look here, I just tell us something. You know, say, Donald sis be here. Police will come dig out some people out of one piece of land. And when they dig them out, they lock them for 3 days and bulldoze with the land.
When?
Pop down the house. Look here. The whole of Lucy know. Go look in your archive. You hear me say to you?
In a me what?
You hear me say, go look in your archive.
In a me archive.
No. I can't say out one word. Any, it come out over. Any name. Where you call the word you call it?
I need Kamozi.
Good. Anything you want to say. You hear me say to you? The bottom line is evil. Nobody now take me out when me leave me the pay rent. If the whole na feet now pay for tax for them business.
No, that's a different rent a different something.
I'm say to you.
Yeah.
Listen to me.
Hold on. Me have to go to the break.
Hold on, yeah.
Me have to go to the break, Hawkeye. You know the call can I? Let me take a break. Hold on.
This time signal is brought to you by the Jamaica Social Investment Fund, JSIF to the GOJ's National Energy Poverty Reduction Project, NEPRP. The time by JSIF is 11 o'clock.
Step into a vibrant celebration of culture where rhythm meets community on the Indian Talent Parade with Dr. Winston Tolan. This engaging program brings you the very best in Indian music, featuring a rich blend of timeless classics and the latest hits. From traditional folk melodies to modern sounds, get captivated by the heartbeat of Indian culture while also showcasing community activities and traditions that bring people together. Tune in and experience the spirit, the sound,